For the record, I am the flesh and breathing man.
All right. Well, I'm glad you're breathing. So
When did you start smoking dope? When did you start smoking marijuana? When? Yeah. Dude, get your hair out of your face. Yeah. I'm better. I can see you now.
Mr. Jones, I'm going to tell you one. Mr. Jones, I'm going to tell you
I'm not allowed to object. I'm my own counsel now. I'm allowed to object, ain't I?
But listen, Miss Pugh, don't speak over me. Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen, Miss Pugh, stop talking over me. If you want to stop talking over me.
Because, Your Honor, I object to
What
the
do
fact
you
that
not
he's calling
understand?
it an
Sir,
ORB.
your objections mean shit to me. So you keep saying, I object, I object, I object. I don't care. I don't care what you're objecting to.
Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
Record, I am the flesh and breathing man.
all right. Well, I'm glad you're breathing. So
For the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion. I need to know the jurisdiction this court is operating under.
have a seat. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
If I don't come here, warrants will be placed, which I will be kidnapped and held hostage, and I do not want that.
Mr. Casanova, in the human flesh. I'm going to stop you right there. And I want you to hear me clearly. Hello, how's it going?
It'll be better.
All right. So my understanding, you want to represent yourself? All right. You're more than welcome to represent yourself, but here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules. So let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I am the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me. There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974, State versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for. So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
What that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness, you need surgery, and you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm gonna go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right, so let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
The
We're
accused
just
in the
stop.
Yes, sorry.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature. Furthermore,
Let me
let the
stop you.
record also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment. And the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from manage to sign counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney in order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is properly identified?
All right, you're in the 187 District Court. It's a criminal court. You're on the 4th floor.
Thank you. This constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under.
All right, I'm gonna
admiralty or military
Counsel,
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm gonna stop you right there. What is gonna end up happening, I want you to hear me clearly. An attorney is coming over for managed assigned counsel, period. That's it. So have a seat, managed assigned counsel will come over. Do you understand? Yes or no?
I do not understand.
All right, do you understand what it means to take a seat?
I do understand.
All right, so take a seat.
Yes, ma'am.
We have talked.
Mhm.
I've informed him that I'm here, to help him in whatever he needs help with.
Mhm.
He's gonna consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay, all right, and so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing, so.
All right, we're gonna go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right, so Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right, who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome. And thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
When'd you start smoking dope? When'd you start smoking marijuana? Yeah, dude, get your hair out of your face. Yeah, I'm better. I can see you now. I can pretty much paint the picture of your life for the next 5 years. Okay, you are like the poster child for Mr. Laid Back. Wow, you got me with your logic on that one. Come on up, Mr. Vick. Mr. Vick, are you going forward today without benefit of a court-appointed attorney? Where's your attorney then? Who's your attorney?
I don't have one.
Then you're doing it without one, right?
Yeah.
Do you want to do it without one or you want to talk to one of ours?
I'll do it without one.
Okay. Dude, get your hair out of your face. Yeah. I'm better. I can see you now. All right. All right. I've got a ticket here and the prosecutor says you're going to plead responsible to double parking and we're going to dismiss a misdemeanor charge of reckless. Is that correct?
Yes.
That's the way you want to resolve this today?
Yeah, miss.
Okay. How old are you?
17.
All right. I understand you're almost done with school.
Yes, sir.
Then what's your plan?
I've been trying to get a job at Father Saturday.
Stop right there. Stop right there. Where have you been trying to get a job?
I'm trying to get a job at the service yard at Holiday Inn at the apartments.
Okay. Why do I have a ROA for a double parking? And we've already got a double ROA for it? Oh,
So everything.
it's confusing. No, it's not the way I'm used to saying it. I thought we had two tickets going. Okay. All right. Where else have you looked?
I looked at the day shop in Logo,
Okay.
and I also looked at Walmart and Buffalo Wild Wings.
And nobody's hiring you?
Well, Walmart, I don't know, but I can't get a response from Buffalo Wild Wings, and I'm trying to go to the holidays.
Okay. Okay. All right. You got a driver's license?
No, sir.
Yeah, transportation is going to be an issue then. All right. So what's your long-term plan? Done with high school, then what?
I'm trying to be an engineer.
So you're going to school somewhere.
Hopefully that's.
Where and when?
Well, I graduate this year, and maybe I hope to go to college. Maybe by the time I'm 19.
Okay. What are you waiting for?
Nothing really.
Then why aren't you going to college now? As soon as you graduate?
I'm trying to finish school right now.
No, as soon as you graduate.
As soon as I graduate.
Yeah. Why aren't you planning on being in school somewhere in the fall?
I mean, I really didn't think about that, but
When did you start smoking marijuana?
when?
Yeah.
2 years ago,
Okay. How often you hit it?
that often,
What's that mean?
like barely.
What's that mean? Give me a frequency, brother. Once a month, once a week.
Speak.
Okay. All right. So on this file, you're not working now, so I'm not going to give you money. I'm not going to charge you fines and costs. I'm going to charge you community service hours. But I also have to give you a little lecture. Dude, I've been doing this a long time. All right. I can pretty much paint the picture of your life for the next 5 years. If you don't do something drastic. Okay. You are like the poster child for Mr. Laid Back. All right. If you're talking about going to school when you're 19, I can guarantee when you're 21, you'll still be talking about going back to school. Guaranteed. I mean, I would bet $100 of mine against one of yours that by then you could come back and we'd still have this conversation about your planning on it. Okay. If you were my nephew, I would put you in a car. I would drive you over to Canton on Ford Road. I would walk you into the recruiting office where you can talk to the Army, the Navy, the Coast Guard, Air Force. They're all in one building. And I would have you go door to door to door and find out what they could offer you if you sign up. Because that's what you need to do. You need to completely shake up your life to make something happen. Have you ever considered it? And I know you don't want to cut your hair, but it'll grow back. Have you ever considered it? Why not? Why? Because that's a valid reason. Wow, you got me with your logic on that one. Listen to me. How are you going to pay for engineering school?
Okay, well, if I get a job, I can pay for it. You know?
No, you can't. You can't pay for an engineering degree working at Walmart. You can't. If you join the military, they'll send you to college. You know, every one of the branches of our armed forces have engineers. There are Army engineers, there are Navy engineers. That's a plan, dude. You don't have a plan.
Okay, well, the officer that got me fired, well, I did have a plan, but the officer that got me fired, he should be able to get something.
Officer got you fired.
Yeah,
Okay, where were you working?
the USC fellow,
Okay, and how did you mean a cop?
yeah,
How did the cop get you fired?
he was a member at the USC, and when it happened, I guess he thought he had a reason.
You mean when this happened? Okay, all right. Okay, so I'll give you that, okay? How's that change what we're talking? We're not talking about this case now. We're talking about your life. How's the cop getting you fired determine whether or not you can afford to go to engineering school?
Because I wouldn't have a job to pay for.
The BYC isn't going to pay for 4 years of college, dude. What were you making? $15 an hour?
I mean, I was making about 14,000 a year, so I mean, I feel.
That ain't even going to cover two.
For the record, he says he's a flesh and breathing man. The judge doesn't blink. Glad you're breathing. That's the tone setter right there. He wants special appearance, under threat, duress, and coercion, the whole sovereign script. While the judge calmly asks the only question that matters at this stage, do you understand what it means to sit down? He does, so he sits. And that's the dynamic for the next 10 minutes. He keeps reaching for magic words, and the judge keeps pulling him back to earth with procedure, copies of indictments, and consequences. When he insists he doesn't understand, the judge moves straight to a competency evaluation, because at some point, refusing to understand isn't a legal strategy. It's a stall. Then the judge offers him a crystal clear analogy. You can't perform your own surgery in the desert and call the doctor.
Well, I'm also adopted, so, you know, the state would pay for it.
Okay.
Okay.
I'll see you again. 30 hours community service, have it done by February 1st. Goodbye.
Mr. Jones, I'm going to tell you one.
Counsel.
Mr. Jones, I'm going to tell you
I'm not
what.
allowed to object. I'm my own counsel now. I'm allowed to object, ain't I? It's only 3 years.
When I'm talking, you do not talk over me. Do you understand that? Because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years. I don't need
Mr.
no
Jones,
help.
I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through void wire. I've been through jury trials. I've done all this before.
Did you go to law school?
No, I did not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years. He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you,
That's
you
3
won't.
years, man. It ain't no time, bro. I got 10 in, 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life and never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. I have to do it all over again.
You realize that if you do this, you cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm
That's
sorry?
Cool.
It's not cool. You're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what I
Ms.
gotta
Martin
do.
does not.
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now.
Tested.
I'm sorry?
That will be tested. We will see about that.
The other problem is obviously you have a right to remain silent with you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions, in picking the jury, in everything that you do, here's the other problem. Here's the other problem. Is he in shackles?
Yes.
Okay. There's the other problem. Because you are in custody, you have shackles on. You want the jury to see you in shackles?
That's grounds for an appeal by itself. I realize that part. They're not supposed to let the jury see me in shackles, so I mean that's kind of like a tipsy-turvy type of thing right there. I know a little bit more than most. I ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge or this allegation?
Meaning what?
I'm just asking the question. Are you aware of any? Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
There may be possible mitigating circumstances. Do you understand that?
Huh? No, nope, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, You do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so if you keep on saying it's only 3 years, that's fine. All right.
You try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental, it will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. You understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
Few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
Take him to the bathroom.
Tell me real quick, Your Honor, I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your security of this.
How am I supposed to use the bathroom in
Sir?
cuffs? How am I supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the cuffs.
She was, man. You know I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law. Now, the issues that present themselves with regard to you representing yourself, obviously, is a logistics issue. Since you are incarcerated, the shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen, because there's for the record, there's a skirt, or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm aware of.
All right. Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
why don't we do this? Why don't we do this, Mr. Jones? Let's start. Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later. It's easier to go that way than to go the other way. You can't have it both ways. What's that?
I use the bathroom, please. I really gotta go, sir. I just need to use the bathroom. I'll be a lot more focused and stuff. I really gotta use the bathroom.
All right, Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him, let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Ms. Martin in that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Ms. Martin
No,
to...
I don't want her near me, around me, or nothing. She can leave.
All right, sign the
She's good to
form
go.
in front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, you have, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need no
Mr.
help.
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please. Mr. Jones, read.
Of representing myself because I didn't trust the lady. That was
Okay,
the whole purpose of
she's
that.
not.
But she's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself.
removing her was for that. Was for me to be able to represent myself.
You will be. Sign the form. Read it.
Was already signed.
All right, read. I'm sorry, I misspoke.
You see, my signature was on that sheet. You already see it was there. What are you talking about?
For step-by-step instructions. Self-representation means you live with your choices. No one's walking you through the rules mid-operation or mid-trial, to her credit. The judge tries a softer path. Appoint standby counsel. Reset 30 days for discovery, set a plea deadline, then trial if needed. Simple, standard, fair. And yet our flesh and blood friend keeps trying to drag the hearing into debates about common law and admiralty. The judge refuses the detour. She's steady, patient, and, this matters, completely in control. The more he recites, the smaller his script sounds. Cut to a different courtroom, different energy. A teenager shuffles in, hair in his face, floating through sentences like he's walking through fog. The judge asks when he started smoking. The kid shrugs. 2 years. Frequency? Not that often. The judge has seen this exact movie 1,000.
Read the form. You said you
I already
didn't read
signed it, man. It's cool. Go ahead.
Read the form. Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't reading. I
get
already
the form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than
I'm
that, are we
objecting
ready
to
to?
Ms. Martin is standing by
Mi-
counsel.
Mr. Jones, I'm
I don't
gonna tell
want
you
stand
one
by
t-
counsel.
Mr. Jones, I'm gonna tell you
I'm not allowed
what,
to object. I'm my own counsel now. I'm allowed objecting, ain't I?
then you say the word objection.
I did. I said I object.
Yep,
How
what are
I'm
you-
supposed
what are
to
you
say it?
objecting to?
I'm
I've
objecting to
removed-
Ms.
I've-
Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was to represent myself because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her
All
wasn't
right, stop.
based on.
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your
All
Honor.
right, bring them down.
But listen, Ms. Pugh, don't speak over me. Ms. Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen, Ms. Pugh, stop talking over me. If you want to stop talking over me.
Where is the verified claim that is being placed against my trust?
You can go back with the bailiff. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I am the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of that estate.
Okay.
For the record, I recognize Ms. Pugh, she's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right, so Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest. You know?
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself? Or are you going to let Mr. Lewis represent you? Or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel, defective defense.
It's overruled.
Okay.
You're running out, aren't you?
No.
Here's the thing, Miss Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Miss Pugh, don't speak over me.
Respectfully, Your Honor, for my incarceration.
Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on, listen to me. Everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. So, Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of your appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today if that's what you want to do. We'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I'm going to be able to.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff.
It's not on my case.
Go back with the bailiff.
It's not on my case.
Welcome to the criminal appointment list.
Yeah, fine, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, just, get ready like you would. Probably it's going to go straight onto a jury. And we'll just get it figured out that way. All right.
Because, Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
an
Sir,
ORB.
your objections mean shit to me. So you keep saying, I object, I object, I object. I don't care. I don't care what you're objecting to. I'm going to hold you in contempt the next time you cut her off.
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying, I object to the
You
denying.
can't
of the motion.
object. You can appeal. Brother, why'd you just waste 5 minutes of my life? You got a motion filed?
Yeah, oh, yes, absolutely. She had, I actually had issues to discuss before I crossed.
But the court reporter needs to pick you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Threats, coercion, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, as stated in my motion, there's actually fraudulent word of since been signed by a judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand that. I'll do it. Okay. The front and second.
That's fine. Just make sure you're talking to the microphone.
Absolutely.
Okay. All right, you can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying
Okay,
to
well,
be
which one do you
dismissed.
want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation. I never even presented a court appearance.
Okay, hold
date
on.
and
You're
all
giving me
that
too
stuff.
many issues. You're talking about swearing in, you're talking about a default judgment. Just pick one issue. We're gonna deal with them one at a time. So what do you want to deal with first? You wanna
Well,
deal
my
with the
main motion.
default?
Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps
I
getting
mean,
set
that's the only
aside, so I
civil
have,
infraction.
I have numerous, I have lots of stuff.
Hold on,
going
that's the
here.
only civil infraction I see with your name on it. So I'm just confirming that we're talking
Yes,
about
it was over
that
the-
charge.
Yeah, sure. It was over
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
Well,
not?
I was notified, I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation, there was no date, and actually how fast it got issued would raises real concerns to me. And then once I received the default in
Okay,
the
hold
order.
on, hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy.
Yeah, I
of the
said
ticket.
it's in there, it's attached to my motions.
Okay, do you have a copy of
Yes,
the ticket?
I do.
Okay, then I'm gonna ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date, where it says appearance date on or before, there's nothing.
Okay,
It
but
didn't
it
give me no
says,
time frame.
it says contact court for appearance date. That
How
means the
long?
monkey's on your back to contact us.
I will also on the bottom of the tickets, it says, if you fail to contact court within the specified amount of time, there was no specified amount of time on here. I had no idea what I was supposed to contact court. I was dealing with trying to get my
Well, let me
attorneys.
ask you this. Did you contact the court?
I was again, as I said, I had no sort of any time frame
Mr.
to
Crucell,
contact the
Mr.
court.
Crucell, this is gonna go a lot easier on everybody if you just answer the question I asked. I'm gonna give you plenty of chance to give me any argument you wanna give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm gonna take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting
Well, once
attorneys.
again, I'm gonna draw your attention to the ticket.
1,000 times. He sketches the next 5 years in one breath. If you don't do something drastic, you'll still be planning to go to school at 21. It's not cruelty, it's impact. He even hands the kid a plan. Talk to the branches, find a track, let someone pay for the engineering degree you say you want. It's the rare courtroom moment that feels like a crossroad, one adult trying to snap a young man out of neutral before the system does it for him, and Then we swing hard the other way to Mr. Jones, a defendant convinced he can out-lawyer an actual lawyer in a felony assault case. He wants to represent himself. The judge warns him, point blank, you will be held to the exact...
My ticket, which I think is the same one you got, is dated February 3rd.
Correct.
Okay, so that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of a default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that, I don't even think it specifies the date.
Well, did you make a note when you received it?
This told me, this said I had I don't remember exactly what date I received this in the mail, but this was scheduled for March 8th.
Okay.
So that was even less than a...
But what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and an a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. That I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice
Well,
of any
well,
sort of.
well, once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
There was no dates.
Okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Crusoe brought this up when you were in front of the Honorable Judge Martin. She did set aside the default of a civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
No.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Crusoe did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because the Judge Martin set it aside.
So the default's already been set aside.
Yes.
Brother, why'd you just waste 5 minutes of my life?
Since March 14th, Your Honor.
Which I object to that because they.
You object to your motion being
No, I
granted?
object to them setting aside my. I object
No. Wait. Listen. She tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of that.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Not, listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly he's threatening me to issue
No.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
But the fact that I was threatened to come in and pay money or warrants.
How was that damage?
And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, they'd have been issued.
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside. And Judge Green never said a word to me about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according, yeah, but that, especially now with the new Chevron overlay, that's just saying that she's just trying to set it aside, that there's no issues.
She didn't try to set it aside, she sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside, she set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know, did she address the money?
No, she never did. No one did. I
Sir,
explained in my motion.
Sir, I'm gonna hold you in contempt the next time you cut her. The first contempt, $100. The second contempt, a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes, Your
record?
Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay, I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing it, so I'm trying to get to the bottom of it.
You're right.
All right. So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At some point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
Do you have, hold on, let me just cut to the chase. Do you have more than just the fact that you think you have a right to travel?
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
Absolutely.
Okay, hold on. I denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the denying.
You can't object. You can appeal.
Okay. Well, I'm just letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine.
Okay.
Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
Yes, absolutely. Well, honestly, Your Honor, like I said, I even have lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about a lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get.
Okay, but that's got nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a stop?
Absolutely.
Then make the argument.
Your Honor, so prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and or in Sibley and Middlebelt, right near actually where I got pulled over, and we had discussed it and talked about it, went on about our day, and this was all prior to this incident. I had two other interactions with this officer where I had specifically told him, I've already been confirmed and doing lawful, I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to and a couple other buddies, right? I gave him that opportunity. It was shortly after that. And I had that confirmation well prior to me even being pulled over. Okay. So then, this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. Like I said, I even told him, I've already had this, I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. Like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay. And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well,
is that a fair summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer that wrote you the ticket didn't think you could.
Correct.
Okay, so that's a difference of opinion there, which has very little, if anything, to do with the probable cause for the stop. Let the prosecutor explain her position on probable cause.
That's it.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his newest motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on the roadway in violation of MCL 324.81122 as adopted by Huron Township ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate the Fourth Amendment. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an ATV on Middlebelt Road, a public highway in Huron Township. Additionally, during the course of the investigatory stop, defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right.
Which I object to the.
Hold on. All right, so the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay, all right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on, I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no? Mr.
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's, stood the test of a challenge. I mean, if it's on the books, all right? If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. Do you need me to clarify that ruling for your appeal reason?
Yes, actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling it
understand?
an ORV.
Sir, your objections mean shit to me, okay? I don't care what you're objecting to. I don't expect people to like every decision I make. That's why there's an appellate process. So you keep saying, I object, I object, I object. I don't care, all right? It's not helpful for today's process. My decision to deny your motion to dismiss based on lack of probable cause is because there was probable cause, because there was a clear ordinance on the books that the officer thought you were violating. That gives the officer a reason to stop you. Do you have any other reasons why you think these matters should be dismissed today?
Yes, absolutely. First off, they're trying to label what my private property is an ORV. It was not an ORV, and it's not even technically an ORV. If you look up the definition of ORV, it is not an ORV. If you look up the definition of automobile or vehicle or any of that sense, that's what it falls under. It does not fall under an ORV. They're just trying to label it as an ORV is what is happening.
Okay. That seems like that would be an issue for trial for you to testify, maybe me to see some photographs, maybe the officer to testify, and then I'll decide whether or not it meets the definitions of the statutes. Would you agree with me? Because that seems like a triable issue.
I suppose, yes.
Okay, well, this isn't the trial.
Well, I understand.
I don't think it's scheduled for trial. Right, this is just motion. All right. Any other issues that you want to hang your hat on as why it should be dismissed? It being these files.
Like I said, from the beginning, it's like the officer had already been notified 2 times prior to this that what I was doing was lawful, that what I was doing was not an ORV, which I had stated to him.
But that's
witness to that
Mr.
as well.
Purcell, with respect, that's all your opinion. Obviously, the officer had a different opinion about all those things.
Well,
right?
The officer chose to retaliate against me is what happened, Your Honor. Which I have the evidence and I have witnesses going on.
Or he had a difference of opinion about whether or not you were driving an ORV.
Or just didn't understand the laws.
That
the
could be
actual
too.
wording.
That could be too. But guess who gets to make those decisions at trial?
Well, honestly, the trial, I'd request a jury trial, which is guaranteed.
Well, you can't get a jury trial on the civil infraction, but you can certainly get a jury trial on the misdemeanors.
Absolutely.
Okay. Do you have anything else to be discussed today on motion day?
Well, yeah, as far as the disclosed CPL, like I said, I have, again, stating I have the body cams and I have my own recording.
But sir, stop. That's going to be an issue at your formal hearing, whether or not you violated that civil infraction. Once again, I got to have evidence, right? I got to take testimony. I'm going to hear from you. I'm going to hear from the officer that wrote the ticket. And then I'm going to decide at formal hearing whether or not what you did was reasonable or not reasonable. But today's just motion day. Today's not the trial. No testimony is being taken.
Oh, I understand that.
Okay. Anything else today?
Well, I guess that's no, but like I said, again, for the record, I do object to moving forward. I do object to anything moving forward from this point.
File your appeal.
No, that's fine. I will.
File your appeal.
I'm going to. That's fine.
Okay. All right. Now, the 200, let's get back to the $280. We'll talk about a jury trial date. Are you going to represent yourself at a jury trial?
Yes, Your Honor.
Good luck. All right. Now, Mr. Purcell, I'm going to strongly suggest that you get an attorney involved in this. And we've got court-appointed attorneys, so we'll be happy to talk to you from this standpoint. I'm not taking you to law school on the jury trial day. I'm going to assume and treat you accordingly that you know the rules of the game.
I understand, Your Honor.
You don't.
Oh.
You might say that. You don't understand the rules.
I do.
Okay? How many jury trials have you had?
None, but I have all the evidence.
How many jury trials have you had?
Your Honor, none, but I have all the evidence.
The evidence isn't the rules. There are a lot of procedural rules that will trip you up if you don't know what you're up against, and you don't. I'm going to suggest to you that even if you want to handle your evidence presentation yourself, you might want to get an attorney involved to help you with the procedural rules, because once again, I'm not going to take you to law school that day. I'm not going to subject the jury to that. It would be a waste of their time. You understand that? All right. Now, and I'm not trying to talk you out of a jury trial. Believe it or not, I'm trying to save you from yourself right now. If you want to have a bench trial, I will be much more lenient with you not knowing what you're doing procedurally, because then it's just our time. But when it's a jury in here, I'm going to run the most efficient jury trial I can. And that means I'm going to treat you like you're an experienced lawyer and know all the rules.
Okay.
All right.
All right.
So if you decide, number one, that you don't want a jury trial, you want to do a bench trial, let me know long in advance of that date so we can save it for somebody else. Or two, if you want the assistance of an attorney, I will give you the ability to talk to one of our court-appointed attorneys and see if they can assist you in the manner you want to be assisted.
Okay.
Understood?
Yes, Your Honor.
Any questions?
Nope.
Anything else? Have a nice day.
Thank you.
Discovery should be provided. Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
Hello, Tariq Samar Tarikade here.
Already, Judge. Court Officer Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
It's going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then we can.
Okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Same rules as the state's veteran trial attorney. No coaching, no do-overs, no ineffective counsel on appeal. And there's a practical nightmare too. He's in shackles. The court will hide them from the jury, but that doesn't solve the bigger issue. Trial is not a place to learn evidence on the fly. He insists anyway. It's only 3 years, he says, over and over. Let that sink in. Only 3 years. The judge tries everything. Time to think, bathroom breaks, a last chance off-ramp to keep counsel. He signs the waiver. He won't even read it out loud. He still objects to standby counsel simply being in the room.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding 3rd degree.
3rd degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have 1 charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
The judge holds firm. We're following procedure. We're going to trial. And that's where we're leaving part 1, on the edge of a decision that will shape a man's next 3 years. He thinks he's taking control. The judge knows he's walking into a buzzsaw of rules he refuses to learn. Up next, a sovereign script crashes into a no-nonsense judge who's had enough, and another courtroom where "I object" becomes the most overused, least effective line in legal history. Buckle up! We enter with Ms. Pugh, who's polite, composed, and absolutely welded to the script. She calls herself a beneficiary, asks for a verified claim against the trust.
Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance, certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
You're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination.
at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them all tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
And tries to talk over the judge while prefacing every interruption with respectfully. The judge doesn't raise her voice. She doesn't need to. She explains the choices. Take appointed counsel, hire your own, or represent yourself. The indictment is the charging instrument. Discovery will come. There's a process here. Every time Ms. Pugh tries to reopen the same door, the judge closes it with the same key. Procedure, timelines, actual decisions. When Ms. Pugh insists she doesn't understand even the punishment range, the judge ends the self-rep conversation because you can't steer a ship if you deny it's on the water. Result, counsel stays, the case moves. Calm, clean.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer. There was
You stood mute, you stood demurrer. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not. They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been denied.
I wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and under they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have
Discovery
discovery?
should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen.
Discovery.
Not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing.
What kind of jurisdiction here?
Personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
Done. Different county, different rhythm. A man waves a stack of motions like a flag. Default judgments. Swearing in, a ticket with no date. The judge listens, isolates a single issue, and then drops the fact the defendant missed. The default was already set aside by another judge because he asked for it. He literally got what he wanted months ago. He keeps objecting. The judge explains again there's an appeal process for rulings, not an I object eject button. Then comes the right to travel argument. The judge cuts to the chase. Denied. There's an ordinance on the books. The officer saw a violation. That's probable cause. If you think the vehicle wasn't an ORV, fine. Bring photos, witnesses, testimony at trial. Motions day isn't trial day. And
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly and the trust is properly functioning at this time. So with that.
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong, because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
Just for the record, I'll put it on the record that I object. But under threat, direction, or coercion, again.
Your objection is noted.
Right, and under threat and direction, coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front? Pardon? Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed? Or I'm trying to figure out how to get the paper.
You can check out at the front counter.
Okay.
This is the part so many pro-C defendants miss. Even a decent point, what kind of machine you were operating, is a trial question, not a magic pretrial dismissal lever. Now we step into the toughest room of the day. A man announces he has COVID, refuses a mask, dials in from the car, and demands a jurisdiction hearing. The judge sets a firm appearance time. He shows up early, proving the court's authority without a word. Then he fires off the full sovereign bundle, trust property, no injured party, fictitious entity, and motions to make the judge and clerk fiduciaries. The judge rejects the theatrics, explains what's actually happening, and sets the case forward to the stage where probable cause is actually decided, at the preliminary examination. He invites written jurisdiction arguments, too, partly to give the defendant a path, partly to create a paper record of why they fail. It's a masterclass in boundaries, firm, lawful, efficient. Back to Mr. Jones for the verdict on his strategy, because there's a deeper lesson here. Judges are not your opponents. They're referees bound by rules. When a defendant treats the rule book like optional reading, the game doesn't stop. The game just gets harder. Only 3 years isn't a strategy. It's a blindfold. That's why the judge kept a professional attorney in the room as standby. Not to undermine him, to protect the trial from turning into a procedural train wreck. And that brings us to the bigger picture across all 6 clips. Sovereign scripts don't beat evidence. Volume doesn't beat rules. And I object isn't a magic word. The people who did best today weren't the loudest. They were the ones who listened, asked direct questions, and accepted that the court moves on a track. Charge, discovery, negotiation, trial. When a judge stays calm and keeps the train on the rails, the script runs out of pages fast. Final thought. You want to argue your case? Great. Bring facts. Bring law. Bring proof. But if your plan is to outtalk the rules will outlast you every single time.